Welcome to this presentation covering Chapter 10 of our textbook. This chapter has to do with the topic of consideration. Before we begin, though, let's pause for a second and look at our contract elements. So going back, we talked about the fact in Chapter 9, the 4 things that every contract has to have. If we think about a contract as a recipe, these are the 4 essential ingredients. Another term for this would be elements. We need to have an agreement, we need to have consideration, we need to have contractual capacity, and we need to have legal object. In Chapter 9, we covered this topic. And in Chapter 10, our chapter today, we'll cover this topic. So we're making progress on getting through these topics. So just wanted to kind of get our bearings. This is going to be the focus of our Chapter 10. So let's get started. Okay, well, there's lots of different ways of thinking about consideration. And one of the things that our textbook does is break it down into what it calls rules or organizing principles. This is, I think, an effective way of talking about consideration, but it's not the only way. But it's how we're going to organize the material, and hopefully it makes sense to you that it's a productive way that we can approach this material. So we have 9 rules for consideration, and we're going to do these in this order. So we'll see as we go through this, you'll see this slide many times. We'll cover Rule 1, then Rule 2, Rule 3, etc. So our first rule is this rule. Consideration is what a person will receive in return for performing a contract obligation. So of course, when we use the term person here, we mean contractor, person in the contract, right? Not just a random person, but somebody who has entered into a contract with somebody else. So we'll call this person a contractor, or another term for it would be a party to a contract. We'll see that this is really just a definition of what consideration is. But the definition that we're actually going to use in this course is this definition. So this is our Rule 1, but it's really focused upon defining what consideration is. And here's our more formal definition. Consideration is the bargain for exchange. So this is kind of a bit of a strange expression in English. What we're saying is it's the exchange. Of course, in a contract, one person is providing one thing, the other person is providing another thing. So that's what the exchange is. If I'm giving you $1 and you're giving me a Coke, for example, that's an exchange. $1 for a Coke for $1, that type of situation. And so that's what an exchange is, but consideration has to be bargained for. So in other words, you're not just giving me the Coke because you're a nice person and you can see I'm thirsty. No, you're giving me the Coke because we've negotiated and I've agreed to pay you $1. I'm not giving you $1 because I'm a nice and generous person who wants to help you out. No, I am giving you the $1 because we have bargained, and in exchange for that $1, I am going to get the Coke. So that's the kind of the 2 aspects. It needs to be an exchange. In other words, both contractors are putting something into this transaction, and it's bargained for. There's a give and take relating to the transaction. It is what each party, of course we're saying each party to the contract, gets in exchange for his or her promise under a contract. So this is our definition of consideration. So we've covered that. Now we're going to go on and cover number 2. So let's go to our next slide. Number 2, for a promise to be enforced by the courts, there must be consideration. Okay, so this is something we've already talked about when we were going through our elements here. We said that we have to have consideration in order to have a contract, that it is a requirement for a contract. So this is just a different way of saying this. We're saying in order to have a contract, we have to have consideration. If we're missing consideration, maybe we have all the 3 other elements, but we don't have consideration, well, we don't have a contract. Okay, so now we're going to talk about some characteristics of the consideration. Consideration is often money. In my example of me giving you $1 and you giving me a can of Coke, I'm giving the dollar, I'm giving money, and you're giving me stuff. And that's a pretty traditional, pretty normal transaction, contractual relationship. The most common arrangement is one person provides money and the other person provides either services or stuff or both. But it doesn't have to be that way. I mean, I could have given you a Starbucks coffee and you could have given me a Coke. Or I could have agreed to um, uh, uh, walk you to the library and you're going to give me a Coke. Lots of different things we can give. It could be a service for stuff, a stuff for service, a stuff for stuff, a service for service. But money is oftentimes the consideration. It's pretty rare that both people are providing money. I mean, that wouldn't make a lot of sense. Hey, I'm giving you $1. Will you give me $1? That's kind of a weird exchange. Sometimes if you're talking about different currencies, for example, you happen to have euros. Well, I might say, I'll give you $1 if you give me a euro or something like that. But usually one of the parties is going to have money. So how much consideration do we need? Well, consideration in the law is largely an on-off switch. If you have it, you're good to go. If you don't have it, nope, you've not satisfied one of the requirements of a contract. So really, consideration can be of trivial economic value. It could be $1, it could be $10, it could be a grain of sand, or as is kind of the traditional tool, is it could be a single peppercorn. You know, when you go to a restaurant where they have pepper mills, and you actually grind the pepper, well, each one of those big balls, which are I guess about the size of a BB, those are called peppercorns. And each one of those peppercorns, its value is much less than a penny. Obviously, if you have several hundred peppercorns, then you have there's some value associated with it. But each one is of trivial economic value. But even that would qualify as consideration, and that obligation is satisfied. It must have, even though it can be nominal or of trivial value, it must have some value, at least to the parties. I happen to have two delightful children, and when they were younger, they would perform or complete various artistic endeavors, finger painting or crafts of various types, and you know, they perhaps were not great works of art necessarily, but my mother adored them, and she would have paid any reasonable amount of money to acquire these items. I did not sell them to her, but she found them of great value, and I found them of great value. But my guess is most likely if you had seen those pieces of artwork, you would think to yourself, not so much, not really of great value, or really of any value. And that's okay, because it's not necessary that whatever the consideration be, that it has to have economic value to everyone. It just has to have economic value to the parties to the transaction. Oftentimes, things that are consideration might just have sentimental value or something along those lines. That's fine. As long as it has some type of value, it's going to qualify as consideration. Sometimes people are confused by this, by the fact that value might just be for the participants and it can have nominal value. They might say, well, what's the whole point of having this consideration requirement if the value could be very small? That doesn't make a lot of sense. Well, part of the challenge in this area is understanding why we require consideration. Why is that a necessary element to contracts? One thing that sometimes students think is the reason that we have consideration is that the courts want to make sure that the transaction is fair. I mean, if only one person is providing something and the other person is getting a free ride, that doesn't seem very fair. And so many times students, at least initially, think, well, the reason that the courts require consideration is so that it's fair. Both parties are contributing something that kind of makes it an even Steven, quid pro quo, tit for tat situation. And that must be what the concern of the court is. They're worried about, is this a fair transaction? Actually, that really isn't a concern for the courts. The courts, for the most part, really don't care whether it's fair or not. The courts are not interested in being anybody's nanny. We'll talk later about how you have to be at least an adult to enter into one of these contracts. And the court's position is, look, if you're a grown-up and you enter into a contract and you enter into a dumb contract or one that's very disadvantageous for you, well, too bad, so sad for you. You should have done a better job, but we're not going to fix it for you because you're a grown-up and you're responsible for your own actions. And so move on with your life, learn from this bad decision that you made, but we're not going to fix it for you. Courts are not interested really in being fair. That's not a major issue, at least in contract law. They're really interested in honoring the bargain, the deal that the parties entered into. It's really in only extreme circumstances that the court starts thinking about what's fair, what's just, things along those lines. So you may be thinking, okay, courts aren't interested in being fair. Well, that's kind of disconcerting, but in any event, well, if they're not interested in being fair, why do they require consideration? What's behind that? Well, the reason for consideration is different. Let's think for a second about a completely different topic, and that is the idea of a writing. There's lots of reasons that we think written contracts are a good idea over oral contracts. Lots of reasons that we like them. For one thing, it provides a better evidentiary trail. After all, if it's an oral contract, one person can say, oh, I promised this, and the other person can say, no, that's not what you said. And it's really hard to prove which one of the individuals are telling the truth and which one isn't. But if you've written it down and you signed it, well, it's a little harder to debate about what's in the document. I mean, people can forge documents, they can alter documents, but it's a little bit more challenging to put that into question marks. So that's one reason why written documents are preferred. But there's a second reason we like written documents. And one of the reasons we like written documents is that as soon as somebody's reducing something into writing, they suddenly get a little bit more serious about it. They kind of have this switch in their head that kind of goes, oh yeah, this really matters. I need to think about this before I go any farther. They get a little bit cautious and they pause and they think, is this a good idea? I mean, I know I was talking about it earlier, but now it's really time to fish or cut bait to decide, do I want to be in this deal or do I not want to be in this deal? And so the act of writing kind of gives us that moment of pause where we really are coming to terms with the idea of, yeah, I'm really going to be bound by this. As we said before, the vast majority of our contracts don't have to be in writing. But in some sense, the consideration requirement is geared towards satisfying that that desire, that need that we have to kind of have that moment of truth. Because if somebody is doing something in a contract and they realize, wait a second, I've got some skin in this game, or you know what, I'm going to have to do something or give something up, even if it's a symbolic thing, they suddenly get, wait a second, okay, yeah, this is a contract. This is real. This isn't play. This isn't a joke. This isn't a we're goofing off. This is a real thing that has legal repercussions. And the fact that there's consideration that I'm going to be bound by kind of reminds me, hey, we're not playing here. This is for real. And so that's really the purpose of consideration, to make sure every party knows that this was for real, that this wasn't some kind of gag, this wasn't some kind of joke, this wasn't something that, hey, maybe we'll do, maybe we won't do. No, you know what? You're having to provide something, even symbolic. So at that moment, you're coming to terms with the fact that, okay, I'm really going to do this. And that's what consideration is about. It's not about being fair. It's just about being sure that both parties get that this is a contract. So we've said that the consideration can be of nominal or very small value, but let's pause and think for a second about what the term value even means. And here's one of our definitional terms. Value is the utility, and you might want to think about utility as being the usefulness, is another word here. The usefulness of an object in satisfying, directly or indirectly, the needs or desires of human beings. So a single peppercorn does have value. It doesn't have a lot of value, but you can grind it up and put it on your cream gravy or your steak or whatever you want to use it for. So it has a slight value. One of my children's finger painting could satisfy somebody's artistic yearnings, right? Okay, so that's the idea behind value. We're not going to stress, though, too much in saying, hey, but that doesn't have a lot of value. Courts aren't interested in that exploration. Okay, so let's look at some categories of consideration. Well, we're going to look at benefit and detriment. Most of the time, in my experience at least, we're talking about consideration. Each one of the items of consideration typically will be a detriment to the person providing it and a benefit to the person receiving it. For example, going back to the situation where I'm giving Bob a dollar and he's giving me a can of Coke. My consideration is the dollar bill. And me giving up that dollar bill, let's say we'll say I had $7 in my wallet. Now I only have $6. That's clearly a detriment to me, the promisor, obviously, because I'm the one promising to provide the dollar. But it's a benefit to Bob. Bob had, we'll say, $14 in his wallet. Now he's got $15. That means he has $1 more. So he is going to be the recipient of the promise to pay $1. So it's a benefit to him. But let's consider the other promise, Bob's promise to me that he will give me a can of Coke. He has the can of Coke right now. Even if he doesn't like Coke, he could sell it to somebody else. And even if he doesn't particularly like Coke, I mean, if he's dying of thirst, he could drink the Coke, right? It would still provide some calories to him, some liquid if he were very thirsty, so it would have value to him in that sense. So giving up that can of Coke is a detriment to him, and now he's the promisor because he's the person who promised to provide the Coke. And it's a benefit to me. I get a Coke that I didn't have before. You can see in these examples, it's not like I'm suddenly wealthy because I have a Coke now that I didn't, or that Bob is suddenly wealthy because he has an extra dollar. These are very small benefits and very small detriments, but they could have even been smaller. I mean, I could have offered to give Bob a penny for a sip of his Coke. The same logic would apply. If I am giving up a penny, that's a detriment to me. It's a benefit to Bob. If Bob is giving me a sip of the Coke, it's a detriment to him and it's a benefit to me. So it's very common for a particular type of consideration to be both a benefit and a detriment. But it doesn't have to be both a benefit and detriment. It could be just a detriment to me if I'm the promisor, or it could be just a benefit to the person, the promisee. Let me give you an example of this. So let's say that the promisee says, I will pay you $1, or I'll pay you $100 if you will not chew any bubble gum over the next 30 days. Well, that is a detriment to me. I now cannot chew bubblegum for 30 days. It's a detriment to me even if I never chew bubblegum. Even if I have never in my entire life chewed bubblegum, it is still a detriment to me. I have the legal right to chew bubblegum, and now I'm choosing to forego that right. And so that would be a detriment to me, and I'm the one making the promise not to chew bubblegum. But it may not really be a benefit to the promisee. I mean, he's really not getting any value from me not chewing bubblegum. I suppose if he finds it obnoxious to hear people smacking their gums or chewing constantly, he might be relieved not to have to see me do that. But we don't have to be persuaded that he's getting a benefit. As long as I, the promisor, am experiencing a detriment, it still qualifies as consideration. It could even be the other category. It could be something that isn't a detriment to me, the promisor, but is a benefit to the promisee. Let's imagine that I have a machine that will infinitely generate ice cubes. You come to my house and I say, you may have an ice cube. That's a benefit to you, but it's maybe not really a detriment to me in that my machine will generate as many ice cubes as I want, whenever I want to. It's a magic ice machine. And so as a result, you are getting the benefit. I'm promising to give you the ice, so I'm acting as the promisor. You're getting the benefit of the free ice cube. Arguably, maybe I'm not at a detriment. So you can see from these circumstances that you can have a benefit and a detriment, or it can be just a benefit or just a detriment. Okay, so let's talk about a different characteristic here. We've talked about benefit versus detriment, but there's another way we can break this up, and that is into promises to do something and promises to refrain from doing something. This is called the act-omission distinction. It's an important one in the law. We're not going to spend too much time on it in this course, but it's a thing that you will hear legal professionals talk about pretty commonly. So in our examples that I've given above, we were talking primarily about doing something. I will give you $1. That's me doing something, giving $1. Or Bob is going to give me a can of Coke, doing something, giving me a can of Coke. Or I'm going to give you an ice cube. That's me doing something. Or I'm going to paint your barn. That's me doing something. So it can be, that's probably the more common, but you can also have forbearance. And that's what a promise to refrain from doing something is, forbearance, when I forbear to do something. For example, giving up chewing bubblegum. That would be an act of forbearance. Or promising not to drive my car after 9 p.m. at night, whatever the particular thing is. There's an interesting historical case, Hamer versus Sidway. This is, again, fairly old, over 100 years old, and this is from New York State, so it's not really part of our common law, but this is a case that has a fair amount of fame associated with it. In this situation, we have a situation of forbearance, and the issue in the case was, did the nephew provide consideration for this contract? And so we're turning to the issue in this case of, let me just flip on over here to our, the question in the case is there consideration? Now there's clearly consideration in what the uncle is offering to do, but the question is, was the nephew providing consideration? So let's look at the fact pattern to get a better feel for what's going on here. So in this case, the uncle, apparently he was a doting, if a little bit of a conservative, stickler type uncle. He wanted his nephew to be well behaved. And so he said to his nephew, if you will promise not to drink alcohol or smoke cigarettes for a period of time, I will give you a $5,000. Well, of course, $5,000 was a lot of money back in 1851. And so the nephew says, sure, uncle, I will be willing to do that. And in fact, the nephew did do that. He refrained from drinking or smoking for the period of time that he was supposed to. Unfortunately, the uncle died before the nephew actually got to collect the $5,000. And so then the nephew had to go to the uncle's estate and say, hey, the uncle and I had this contract. He needs to pay me $5,000. He's dead, so I need the estate to pay. Well, the estate contested that. And the basis for the contesting was, well, nephew, you didn't provide any consideration. You didn't promise to do anything. Well, the nephew said, well, that's true. I didn't promise to do something, but I promised to refrain from doing something that I had the legal right to perform. I don't know what the drinking age was in 1851, or even if there was such a thing, but the nephew, at least for some of that time, was over the legal drinking age and the legal smoking age. So he had the legal right to drink and he had the legal right to smoke, and he refrained from doing so. So he acted with forbearance. Now, of course, the argument might be, well, how did that benefit the uncle? Well, again, it's not necessary that it benefit the uncle. It's sufficient that it was a detriment to the promisor. And in this case, the promisor is the nephew. The nephew is the one who's making the promise. And of course, we see this pattern. We've seen it before. The OR, this person makes a promise. The promisee is the person who receives the promise. So when we're talking about the forbearance of not drinking alcohol and not smoking cigarettes, the nephew is the promisor and the uncle is the promisee. Now, you can make an argument that the uncle did benefit from the contract because he cares about the well-being of his nephew, and maybe if his nephew had become kind of this wild kid, maybe that would have reflected poorly upon the uncle and would have damaged the uncle's reputation. We're not sure all the ins and outs of it, but we're sure that it was a detriment to the nephew. It would be a detriment to the nephew even if the nephew never wanted to drink, never wanted to smoke, because he was surrendering his legal right to do so. And so that would be forbearance. So in this situation, the court decided, well, yes, we do have consideration. Obviously, the $5,000 that the nephew was going to, that the uncle was going to provide as consideration. But this promise is also consideration because it's a type of forbearance. Okay, so let's consider the two types of contracts that we talked about. Actually, we talked about lots of different kinds of contracts, but one way we thought about dividing up the universe of contracts is in dividing them up into bilateral and unilateral contracts. It's very hard to find pictures of unicycles and bicycles together. I don't know what the deal is, but for whatever reason, people don't like to put those two together. So I had to work really, really hard to find this picture. But here we have the bilateral contract, which is like a bicycle, 2 wheels. And we have a unilateral contract, which is a unicycle, 1 wheel. So when we think about this, it's 2 promises, and this is 1 promise. So in a bilateral contract, we have 1 promise for another promise. So going back to the example we have of the uncle and the nephew, both of them are making promises. The nephew is saying, I promise not to drink or smoke for this period of time. The uncle is saying, at the conclusion of this period of time, I promise to pay you $5,000 if you haven't drank, if you haven't smoked. And so that is a bilateral promise. But we can also have a unilateral promise, which is a promise for an act. So that would work in a different way. So imagine that I want to buy Bob's Coke. And I say to Bob, Bob, I promise to pay you $1 if you hand over that Coke to me. Well, what I am proposing is a unilateral contract. I am making a promise. I promise to give you $1 if Bob does a particular act. Hand the Coke over to me. But let's say Bob says, okay, I accept your contract. I promise to hand the Coke over to you. Well, Bob isn't accepting my offer of the unilateral contract. He is saying, I want a bilateral contract. You are promising to pay me $1. I'm willing to promise you that I will turn over the Coke. So really, Bob rejected my unilateral contract, and he is countering with a bilateral contract. I come back and say, wait a second, I don't want a bilateral contract. I'm all about the unilateral contract today, so I reject your proposal of a bilateral promise for a promise contract. I want a unilateral contract. The only way you can accept my offer is by handing the Coke over, by completing the act. If you do that, you've accepted my contract, and I will give you the $1. So that is how that can work. So you can see how in most cases, the consideration is going to be the promise, not the actual stuff. And this is in everyday conversation, and I'm sure I've already done this several times, so I apologize for this, but we oftentimes think about the stuff being the consideration. For example, when we say, I promise to give you $1 if you promise to surrender the Coke, most of the time we would say, well, the $1 is the consideration or the Coke is the consideration. But technically, it isn't those 2 items. It's the promise to pay the $1 that's the consideration. It's the promise of providing the Coke that's the consideration. So technically, in a bilateral contract, both of the promises are the consideration. In a unilateral contract, this promise is the consideration, and then the action is the other consideration. So that's just a fine point. I don't want to spend too much time on it, but it is logistically kind of what's going on here behind the scenes. So we've looked at our first 2 rules of consideration. Now we're going to go on to our third rule. Third rule is promissory estoppel is a legal enforcement of an otherwise unenforceable contract due to a party's detrimental reliance upon the contract. Let's break this up. I mean, before we get started, let me pause and say, I wish this weren't one of the rules the textbook talks about, because this really isn't a rule about consideration. This is a rule about the absence of consideration, usually. So it's kind of unfortunate that the textbook writers did this, but we can work around it. But I just want to flag this and saying it probably doesn't belong on this list. Let's first of all look at the expression promissory estoppel. This is a pretty common one under the law, and to break this down, to remember what this means, it's helpful to actually look at the structure of these words. We can see in the word promissory, we see the word promise. And we see in the word estoppel, we see the word stop. So what we have here with promissory estoppel is we have one person making a promise. And as a result of making that promise, we'll say Bob made a promise, then Bob is estopped, or he's stopped from not following through with the promise. That's how promissory estoppel works. Whenever you see the word estoppel in law, notice the word stop in the middle. Okay, so this is what we do when we have a fatal flaw in our contract. Let me go back to our picture here, or our list of characteristics. If we're missing any one of these 4 items or any of the sub-items under these categories, we don't have a contract. We know that. But sometimes, even when we don't have a contract, we may have something that a court may choose to enforce to some extent. And this is when we're missing one of these elements, we might have promissory estoppel. So promissory estoppel is not a type of contract, and it doesn't arise when there actually is a contract. It arises only when the contract that we attempted to do failed. It's not a contract. So this is a way that courts sometimes will kind of slide in and say, wait a second, this doesn't feel right. We know there isn't a contract, but it doesn't seem like somebody ought to be able to get away with what's going on here. So we're going to do something else. And this is our workaround for this non-contract. Okay, so what is promissory estoppel? Here's our technical definition. It's the legal enforcement of an otherwise unenforceable contract due to the party's detrimental reliance on the contract. Let's look at a couple words here. We have the phrase otherwise unenforceable contract. We saw the word unenforceable contract in Chapter 9, and we talked about how that really was an oxymoron. If it's unenforceable, it's not a contract, because one of the things that is part of the definition of contract laws is it has to be enforceable. So it's like saying Walking Dead, or The Little Bighorn, or something like that. It inherently is conflicting. You're putting 2 terms together that can't go together. And so an otherwise unenforceable contract really isn't a contract at all. Let's look at the next expression, which is detrimental reliance. These are terms that pretty much have their ordinary meaning. Let's consider detrimental. Something that is detrimental is negative. For example, cigarette smoking is detrimental to your health. Going on a plane trip is detrimental to your financial well-being. Staying up all night is detrimental to the way you're going to feel tomorrow. All those things. It has a negative implication. That's what detrimental means. Reliance means that you have counted on something. You have planned that something is going to happen, and maybe it hasn't. For example, imagine that Bob and Teresa are engaged to be married. Bob has rented out the reception hall. He has arranged for the minister to be at the wedding. He and Teresa have sent out wedding invitations. He's rented a tuxedo. And now it's 1:55 p.m. on the afternoon of his wedding. The wedding is supposed to start at 2 p.m. And Teresa calls him up and says, I'm not showing up. I've decided not to marry you. Well, guess what? Bob relied upon Teresa to fulfill her promise. She had said, yes, I will marry you. She had even said, yes, I will marry you at this time, at this place. And she's not going to follow through with that. So Bob relied upon Teresa. And he relied upon Teresa to his detriment in that situation. I mean, he spent money. He had to rent the hall. He had to rent the tuxedo. Probably there were flowers and other things. Maybe some of those things Teresa paid for, but perhaps he paid for some of those things too. And so he is financially less well off because he relied upon what Teresa said. Now that actually would not be an enforceable contract for other reasons. We'll talk about that in a different different lecture. But the idea that a person can be harmed when they trust somebody else to do what that person said isn't a novel idea. We've all been in that situation where somebody has said, I'll do X, and you thought, okay, I can count on that person to do X. They don't do it, and it causes you problems. That's not an unusual situation. Now, if the person who let you down, you and that person had entered into a contract about the topic, then you have contractual rights. You can enforce the contract. You can sue that person. But sometimes you don't have a contract, perhaps because one of those 4 elements is missing. And so when one of those 4 elements is missing, but you've still been harmed by your reasonable reliance upon somebody's promise, the courts sometimes will say, you know what, it's not a contract, but we're still going to try to fix things for the person who was wronged. So when does the idea of promissory estoppel, when does it kick in? Well, first of all, I think it's important to keep in mind is that courts don't ever have to apply the doctrine of promissory estoppel. Courts have a lot of discretion in this area, and some courts will say, well, I'm only going to apply the doctrine of promissory estoppel when it's really, really unfair. Other courts might be more willing to to follow this doctrine. It's because that this idea of promissory estoppel is an equitable notion, and so courts don't have to follow it, don't have to apply it every time that maybe these circumstances come up. Let's look, though, at some factors that might play a role in whether a court would apply this doctrine in a particular case. Well, obviously, to have promissory estoppel, one party has to make a promise. You can't have promissory estoppel without a, promise, right? The other party has to rely upon that. We've already talked about that with this idea of reliance. The other party does, in fact, okay, so one party makes a promise knowing the other party will rely upon it. Teresa knew Bob was, renting the reception hall, that he was renting the tuxedo. She knew it because he probably told her, but also she knew it just kind of common sense. You're getting married, obviously you're going to have to make some arrangements. And then the person actually does rely upon it. It's not just that he could have relied upon it, but he actually did rely upon it. And then this is the real kicker. Usually those first 3 fall into place really nicely. This is the one that might be a bit more of a challenge, and that is the only way to avoid injustice is to enforce the promise, at least to some degree. Let me give you an example of how promissory estoppel might work out. Imagine that we're in a classroom together. We'll say there's 30 students in the classroom, and I say, Bob is in the very back row, and I say, during class, I say, students, every semester I randomly select one student, and this student will get an all-expenses paid trip to Paris, France. You will leave for Paris, France the week after the final exams. You don't have to do anything to earn this. It's just, my gift to that one student. And the student that I have randomly selected this semester is Bob. Bob's like, oh my gosh, really? Gosh, thanks. He's not quite sure what to do with this information. So after class, he talks to a few students and he goes, what did she mean? Was she serious? And some of the students say, oh yeah, she's serious. In fact, that's why I signed up for the class. Groover does this every semester, and she really does end up giving this free trip. And so I signed up for it in part because I hope to be the person. Congratulations that you're going to be the person who gets this free trip. And Bob says, well, can you tell me the name of somebody who's gotten this free trip before? And so one of the students goes, yeah, I remember Louise. She got the free trip. Here's Louise's cell number. Why don't you give her a call? Well, Bob calls up Louise and goes, yeah, it was a wonderful trip. I went to Paris. I was there for a week. I stayed at the really expensive hotel. I got first class plane tickets. There was a significant meal allowance. It was really, really amazing. I'm so glad that I had the opportunity to do that. And so now Bob is pretty convinced that Groover is actually going to deliver the free trip. So he starts thinking he's got about 15 weeks until it's time for him to go to Paris. He doesn't know any French. He doesn't really know very much about Paris. And so he's thinking to himself, gosh, I want to make the most of this trip, and probably I ought to know at least a little bit of French, and I ought to know at least what I want to see when I'm in Paris. So Bob goes out and buys a couple guidebooks. He also gets some French language tapes. Then he starts looking at his closet, and gosh, he thinks to himself, if this hotel is really, really expensive, I mean, I don't necessarily have the best clothes. Maybe I need to get some nicer slacks and maybe some button-down shirts so I don't feel like, I'm going to embarrass myself walking through the lobby of this fancy hotel. And so Bob spends about $200 on clothes. He ends up spending about $300 total on the guidebooks, the French language tapes, and some clothing articles. Anyway, the semester continues, and Bob is now coming in to take his final exam. He turns it in, and he says to Groover, "Well, Professor Groover, I just want to say thanks again for the free trip to Paris. When do I leave? What do I need to know in order to be ready for this trip?" Well, I say to Bob, well, unfortunately I've changed my mind. I'm not going to be able to do it this semester. And Bob says, what do you mean? You told me you were going to do this. I go, well, Bob, there really wasn't any consideration. You didn't have to do anything. In fact, you didn't even have to continue coming to class. Glad you did. Hope you did well in the final, but really it wasn't necessary. So because there was no consideration on your part, therefore we didn't have a contract, so, I don't have to send you to Paris at this point. But then Bob remembers this lecture, right? He remembers this doctrine of promissory estoppel. He remembers that when one party makes a promise, in this case it would be Groover, and I, Groover, know that the other party will rely upon it. It makes sense I would, because since I've actually followed through on this promise before, it would make sense that I would know that you would trust me, and that clearly in this case Bob actually did trust me. Then the only issue is whether the court finds the only way to avoid injustice is to enforce the promise. I mean, the court might require that I actually give Bob an all-expense-paid trip to Paris, but the court might also find something else that's smaller to be a way to resolve the issue. For example, the court might say, Groover, pay Bob the $300 that he's out. The guidebooks, the language tapes, the clothes. And the court might even say, well, you don't have to pay him the whole $300. I mean, after all, he can resell the guidebooks to half-price books, also the language tapes, and, he could sell those clothes to a secondhand or thrift store, or he could sell them on eBay, or after all, he probably needs, eventually needs some new clothes. So, it's not like those clothes are only available to be worn in Paris. So the court might even say that I don't owe the full $300 under those circumstances. So you can see how promissory estoppel can work even if there is no consideration on one of the parties. And you can see in this scenario, under promissory estoppel, there is no need that both parties make a promise, or that we actually have either a bilateral or unilateral contract. In fact, we don't have a contract at all under this scenario. As we said before, no consideration is required for the detrimental reliance. But keep in mind, again, promissory estoppel is not a contract. The whole point is there is no contract. If there were a contract, we wouldn't need promissory estoppel. We just apply the concepts of promise of contract law to the scenario. Okay, so now we're up to, we've done our first 3 rules, now we're to rule 4. The court seldom considers the adequacy of consideration. We've already talked about this idea, but let's just spend a couple seconds making sure that we've solidified it. We've said that we must have consideration, that both parties have to provide consideration, that the consideration has to have value, at least even though it can be nominal value, and that it either has to be a benefit to the recipient or a detriment to the giver. But the court isn't going to judge to say, oh, that's not enough consideration, or that's a lot less consideration than what the other person's providing. The court is not going to micromanage the consideration. The court isn't going to be a nanny. It's not going to help a poor negotiator. In fact, there's a case that it covers, that's in your textbook, that says a single dollar can qualify as consideration in certain cases. So let's go on to number 5. An illusory promise is not consideration at all. So We've said how consideration can be a very, very trivial economic value, but it has to have some economic value. We all know what an illusion is. If we've ever seen a magic trick, it looks like X is happening when really X isn't happening. Or we don't think X is happening when it in fact is happening. We have an illusion. And of course, if this is a little optical illusion here, if you look at it for just a couple seconds, it'll start looking like it's spinning. Well, obviously it's not spinning, it's stationary, but it creates that illusion. So something appears to be something that it's not. What's an example of an illusory promise? Because that's something that isn't consideration at all. It sounds like consideration, it quacks like a duck, but it really isn't a duck. So what is an illusory promise? It's a situation in which a party appears to commit to something, but really has not committed to anything. It's not a real promise, and therefore it's not really consideration. This usually arises when the promisor continues to control whether he or she will do something. For example, if I were to say, let's say I go into Bob's bakery, and he's got all these elaborate cakes and pies and other dishes in his display case. And I say, you know what, Bob, oh my gosh, these cakes and pies look awesome. I'm throwing a dinner party on Friday, and so I will come by your bakery on Friday. Are you going to have the same stuff here? Bob goes, oh yeah, I have the same stuff every day. I go, okay, you know what, I'm going to be back on Friday around 2 p.m. and if I see something I like, I'm going to buy it. You can count on the fact that if I see something I like, I'm going to buy it. I was like, oh, okay, great. I'll look forward to seeing you on Friday. Well, at 2 p.m. on Friday, I come in. Bob has exactly the same merchandise as he had when I came in before. And he says, oh, I'm glad you're back. What do you want? What do you want to buy today? And I look at all the windows and I say, I see you have the chocolate cake like you did last Wednesday. I see you've got the apple pie. I see you have the angel food cake. Bob says, well, I have everything, exactly the same stuff I had when you came before. So tell me, which item should I box up for you? And I go, well, you know, just none of it really strikes a chord with me today. I don't think I'm going to buy anything. Bob says, well, what do you mean? When you left here, you seemed committed to buying something, and it's the same stuff today. Surely you can buy something. And I go, no, I don't know. I said, if I like what I see, I will buy it. Today I just don't like what I see. And after all, I, Cynthia Groover, can control what I like and what I don't like. And Bob can't disprove it. He can't say, well, Cynthia Groover really did like that chocolate cake then. No, there's no way to prove what I really wanted. I'm the only person who knows what I really want. So an illusory promise is that type of promise. And we'll see additional examples of illusory promises later on in this chapter. So that is not consideration at all. Now we're going to look at another thing that sounds like consideration, but it really isn't, and that is past consideration is no consideration at all. Okay, this is again like kind of that Walking Dead idea, because past consideration, it occurs when a person does something for somebody and then negotiates over it. So the order of events is wrong. The way that you ought to have a contract is the parties get together and they say, I'll do this. No, I don't want that. Well, what if I do this? Well, I'll do this. Well, okay. Then they finally reach an agreement. And both parties know, well, I've got to do X and you've got to do Y, and we're doing it because that's part of the deal. Then once they reach the conclusion, they both do what they're supposed to do. And those two actions or those two omissions or whatever it is qualifies as the consideration. But let's imagine a different scenario. Imagine for a second that you're my next door neighbor. You've been, when I pick up the mail on Monday from my mailbox, I see you out of the mailbox and you're coughing and, you know, you're still in your bathrobe and it's 3 p.m. And I say, gosh, what's the matter? You say, I've been so sick these last few days. I've been to the doctor. I've got a fever of 103 and I just feel so terrible. I go, oh gosh, I'm so sorry to hear that. Well, we go back to our houses, and later on the next day, I'm mowing my yard. And I think to myself, you know what? I'm going to be a good neighbor. My next door neighbor's sick. I'm already out here with my lawnmower. I might as well just go over and mow my next door neighbor's lawn. After all, I'm a good neighbor, and I want to help out. So I mow my lawn and I mow his lawn, or your lawn, I guess, in this example. The next day, I'm at my mailbox and I see you and you see me, and you're still pretty sick. And you say, "Oh, was it you who mowed my lawn?" I go, "Yeah, it sure was. Gosh, that was so nice. Gosh, I don't know how I was going to be able to mow it. I just am so weak and feel so bad. And gosh, thank you so much for doing that. You are an awesome neighbor. You know what? Next week, I'm sure I'll be stronger. I'm on antibiotics and I'm already feeling a little bit better. So I'm sure a week from today, I'll be well enough. And I'll tell you what, when I mow my lawn, I'll mow your lawn too." Well, gee, thank you. That's very neighborly of you. I really do appreciate that. I hope you feel better soon. If I can get you something, let me know. So we go back to our houses. The week passes. We're now to the week anniversary of the promise. My lawn's getting a little hairy at this point, but I'm not going to mow it because I know that my next door neighbor's going to mow it. So I go about my week and I go home the next day and it's still not mowed. But I see that my next door neighbor's yard, your yard, is mowed. I'm confused. Well, gee whiz, it looks like my next door neighbor mowed his or her lawn but didn't mow mine. So I go over and knock on the door and says, "Hey, just checking on you. How you feeling?" And you bound it. You go, "Gosh, I'm feeling so much better. Thank you for asking. It was really miserable last week, but you know what? I'm back to 100% now." And I say, "Oh, that's wonderful news. I'm so glad to hear that. Listen, I was wondering about when you were going to be able to get to my yard." And you go, "Oh, you know what? I know I did mention to you last week that I'd mow your yard when I mowed mine, but you know I changed my mind. I just didn't really feel like doing it." I say, "Well, are you still not well enough to do it? Because you know I can mow it this week, and the next week you could mow it when you're really 100%." And you say, "Well, you know, thanks for that, but no, I don't really think I'm ever going to want to mow your lawn because I don't really like to mow lawns, and so I just don't think I'll do that." I say, "But I mowed your lawn. Remember when you were sick? You know, how about if we wait until next time I'm sick, and I'll let you know, and then you can mow my lawn for me then." And you say, "Well, you know, that's an interesting idea, but no, I don't think I'd really want to mow your lawn even if you were sick, because I don't really like to mow lawns, and I don't really like to mow my own lawn, but I certainly don't want to mow somebody else's, so I don't think I'll be doing that." Well, I'm pretty mad at this point, and I think to myself, I mowed my neighbor's yard. He promised to mow mine, but he didn't. Surely that's a breach of contract. But no, it's not, because I got the events out of order. What I should have done is I should have negotiated with you, my neighbor, about the lawn mowing before I mowed. Once I actually complete the mowing and then we negotiated, I can't take back that mowing. I provided that mowing free, gratis. It was a gift. You had no contractual obligations at that point. So you can't create an obligation after the fact. There's actually a case in the textbook about that topic. There was a basketball player, you might have heard of him, Allen Iverson, a very prominent basketball player. Anyway, he had, when he was, I think, maybe even still in high school. So he was an up-and-coming basketball player back then, but obviously he wasn't professional. So, you know, he had hopes of accomplishing a lot, but he hadn't gotten there yet. Anyway, he had a trusted kind of a mentor. I think it was almost like an uncle to him named Blackman. Anyway, so there were talking, and Iverson was kind of a clever young man, and was trying to figure out how to best market himself when he gets to that point. And he thought, you know what? Maybe I need a nickname, something like Air Jordan, that will kind of help me be more successful at marketing myself if I get to be that really successful basketball player. Well, Blackman came up with the idea of the answer. That's what your name should be. You are the answer on the basketball court. Iverson goes, oh, that's awesome. I like that. That's clever. It's descriptive. It's positive. Yeah, I think that's a good one. So anyway, Allen Iverson goes into basketball, eventually becomes a professional, and he uses the term the answer. But before he gets to be very big, he says to his friend, Mr. Blackman, hey, Uncle, I think is what he called him, you know what? You came up with that really awesome nickname for me. And, now I'm quite successful, hoping to be more successful, but pretty successful now. And I would like to reward you for that help that you provided to me. So I'm going to give you 10% of all the profit I make from this nickname, from this title, the answer that you came up with. Well, Mr. Blackman says, gosh, that's generous, Alan, of you. Thank you. And so they kind of, over the years, kind of grow a little bit apart. Well, Mr. Iverson becomes very, very financially successful, both playing basketball, but also in marketing himself with this nickname, The Answer. Well, Mr. Blackman isn't getting any money from this. So he eventually goes to Mr. Iverson. He goes, Alan, I'm so glad to see how successful you are. And I'm so pleased to see that the nickname that I came up for you has been so rewarding for you. I'm wondering kind of when I'll be getting my share of that money. And Alan says, Blackman, thank you so much for your support over the years, for your friendship and your mentorship. I really do appreciate it. And also thank you for that nickname. That's very positive, very good impact upon my career. I thank you for that. But no, I don't think that I'll be giving you any of the money from that. Well, Mr. Blackman goes, but we had an agreement. Remember, I was supposed to get 10%. And Alan, of course, says, well, you shouldn't have told me the name before we came up with that agreement, because once you told me the name without any negotiation, that would no longer provide consideration. I mean, if you had said, I've got the best nickname for you, if you end up using it, will you promise to give me 10%? And I had said yes at that point, well, then we would have had a contract. But you gave me the name first, and therefore your giving me the name would only be past consideration. So poor Mr. Blackman, he did not get any money from Mr. Iverson. So let's go on to number 7. A promise to do something you are already obligated to do is not valid consideration. This is oftentimes called pre-existing duties. Okay, so if you, I've wonderful parents, but my guess is this is probably something you can relate to from your childhood, perhaps. When I was growing up, my dad would tease me at various points. Oh, you know what? Once you're grown up, I'm going to present you with a bill for all of the expenses I had to bear for you, all of the meals I fed you. I'm going to make you pay rent for all those years, all that kind of stuff. He never did present me with a bill, but that idea was out there. But you know what? Even if he had presented me with a bill, he wouldn't be able to collect on it. He wouldn't be able to collect on it for several reasons. For one, it's past consideration because we didn't negotiate over it until after the fact that he had spent the money. He also wouldn't be able to because at the time that he was incurring these expenses, I was a minor, and so I lack legal capacity. So that's another reason it doesn't work. But a third reason that argument doesn't work is that he had a duty to feed and clothe me. He had the pre-existing duty, that of a parent, to care for minor children. But it's not just parents who have that duty. Police officers have the duty to protect the citizens in their particular geographic area. Firefighters have the duty to rescue people in distress. And there's other people who have duties, but those are maybe the classic examples of people who have duties in this area. So if, let's say that grandma is on the second floor of her house, there's a fire on the first floor. She can't get down to this first floor because the staircase is engulfed in flames. She is standing at the window at her second floor looking out, and she sees the fire truck rushing down the road to her house. One of the firefighters gets off the fire truck, rushes to the house, and he has the ladder in his hand. And grandmother says, "Oh, I'm so glad to see you. Please put the ladder against the wall and help me down so I will live." And the firefighter goes, "Not so fast, Grandma. Do you got any jewelry on you?" And grandmother's like, "What do you mean, jewelry? Why do you care if I have jewelry?" And the firefighter says, "You know what? I will put the ladder against the wall and even climb up the ladder to rescue you if you've got some good jewelry that I can keep. Do you got like an engagement ring or maybe a necklace or something I can have? Something preferably with diamonds. Certainly I would like some gold or some platinum." Grandma's like, "What do you mean? What is this you're talking about?" But the flames are getting closer and closer to Grandma, so she decides, "Well, okay, I'll throw down my engagement ring and my wedding ring and my pearl necklace that I'm wearing around my neck." Anyway, she throws those items down. The firefighter picks them up, puts them in his pocket. He puts the ladder against the wall of the building, goes up the stairs, helps Grandma down, and Grandma's life is saved. Grandma then says to the firefighter, "Okay, firefighter, thank you for rescuing me. I'd like my jewelry back." The firefighter says, "Oh, Grandma, that was, you gave that to me so that I would rescue you. So, no, it's mine now. It's not yours." But the firefighter is incorrect under these circumstances because he had the pre-existing duty to rescue Grandma or anyone else in a burning building. That's how he's paid. The city of whatever, let's say city of Plano, has paid him for those services or her for those services. And so therefore, um, he or she already had the existing duty to fight fires. This issue can arise also when you have a pre-existing contractual duty. Imagine that I had a contract that I am supposed to paint your barn. And we've negotiated that I will paint your barn for $2,000. And it's supposed to be completed on the Thursday. Because you are going to use this barn on Saturday for your wedding. So you want to make sure that it's all beautiful and neatly painted. So I've been working away on the paint, and I'm about 2/3, 3/4 done on Thursday morning. You come out and you say to me, "Okay, Groover, you're doing a great job, but you really do need to finish up today because tomorrow we have the wedding rehearsal, and of course on Saturday we have the wedding, and so I want some of the fumes to dissipate. So go ahead and finish it up today according to the terms of our contract." And I say, "Well, you know what? I'm really planning on taking the rest of today off. I will be back on Monday to go ahead and finish painting your barn." "You know what? Monday? Well, that won't work for me. I'm getting married on Saturday. I need it to be beautiful Saturday. Monday is going to be too late." And I say, "Well, okay, I understand what you're saying. I would be willing to continue working today if you, instead of paying me $2,000, pay me $3,000. "What? But our contract says that you will finish today for $2,000. "Well, I don't think I'll be doing that unless I get the $3,000. Well, I had the pre-existing duty to finish painting the barn today. So I don't need to get any more money in order to accomplish that duty since I've already committed to that duty. So even if you agreed to pay me $3,000 instead of $2,000, you actually would not have to actually honor that extra $1,000 worth of payment because there's no additional consideration for that additional $1,000. Let's look at some situations, though, in which even when you have a pre-existing duty, you might be able to treat fulfillment of that pre-existing duty as if it were consideration. So let's look at that. One could be a situation where there's unforeseen circumstances. So going back to me painting the barn, let's assume that it's been, let's assume that you're getting married in August. Well, usually July and August are very dry months in this part of the country, but let's assume that there's just been really, really unusual weather, and as a result, it's pretty much rained every single day. And because while I'm painting the inside of the barn, it's not completely watertight, and so you really don't want to paint it when it's raining or it's been wet, because the boards can warp with the paint, and so you really don't want to do that. So because of these very unusual circumstances, that I haven't been able to accomplish as much as I ordinarily would. Under those circumstances, you could see the agreement to paint, to meet that deadline. You might need to pay more money. So an example of these unforeseen circumstances would be like an act of God, the super rainy July and August. Now, it wouldn't work if it just rained one day or just rained 2 days. It would have to be a dramatic difference between the climate that we'd ordinarily have. Another term for act of God, or at least a related term, is force majeure. Now, this basically means the same thing as act of God. It's a little bit broader than act of God. By the way, the term act of God does not have a religious connotation, even though it has the word God in it. Act of God is really just an expression meaning something that a human being doesn't have control over. That's kind of a natural event, such as a hurricane or a tornado or a forest fire or something like that. A force majeure is a little bit broader. It can incorporate things that human beings do have control over. It's just that an individual human being doesn't control. So, for example, a force majeure would include things like a strike or a war. Obviously, those aren't, when I say strike, I mean like a strike of workers against a particular employer. Those are not natural phenomenon, but they are things that no individual person can control. And so in those very unusual circumstances, giving the person who is fulfilling the contractual obligation more money to reflect the additional expense or hassle that person is experiencing could still be enforceable. Another situation might be when there's additional work under the contract. So let's imagine I'm painting your barn, but I discover as I'm painting it that there are several boards that have been eaten through or are very compromised because of termites. So I actually have to go out and buy new take off the pieces of wood that have been destroyed by termites and put up the new boards. I have to condition those and shape them just the right way so they fit. And so I'm having to do significantly more work and also incur some expenses because of this unanticipated expense that is necessary in order to complete the contract. So that's a second situation where even when I have a pre-existing duty, I might still be able to claim that my performance of that qualifies as consideration. Another scenario is under the UCC. We talked about the UCC in Chapter 9. That's the Uniform Commercial Code. And again, we've talked about Article 2. That's really the only article that we're focusing on in this course. You don't need to know what part of Article 2 we're talking about it. But here's the UCC, or the Uniform Commercial Code's exception to this pre-existing duty rule. An agreement modifying a contract within this article needs no consideration to be binding. So we can modify a contract and we don't need to have additional consideration. Now that's not the rule in the common law. Again, in the common law, in contracts that are controlled by the common law instead of the UCC, if you want to modify a contract, you are going to have additional consideration supplied by both parties. Let's look at the next element. A signed agreement which excludes modification or rescission except by a signed writing cannot be otherwise modified or rescinded, but except as between merchants, such as a requirement on a form supplied by the merchant must be separately signed by the other party. So you can limit the amount of modification to require that it be a signed writing. So here's an example. Let's imagine that Toro, the lawnmower manufacturer, has a contract with Walmart to supply lawnmowers to Walmart that Walmart, of course, would sell to the general public. They've finalized that particular contract, and initially that contract says that Walmart just wants green lawnmowers. But as the season progresses, Walmart discovers that consumers really are into the blue lawnmower this year. And so Walmart says, well, now send us 80% green lawnmowers and 20% blue lawnmowers. And that will be okay to have that change. Of course, Toro has to agree to it, but it's okay to modify the contract even if there is no additional consideration under those terms. Now we're ready for the accord and satisfaction. We've covered our first 7 rules of consideration. Now we're ready for number 8. An accord and satisfaction, this is usually thought of as a one-unit thing. So these two things together is an arrangement between contracting parties whereby one of the parties substitutes a different performance for his original duty under the contract. Okay, so this is typically, another term for this would be a settlement, would be probably the common term for this. So imagine that, we'll go back to the example where I'm supposed to paint Bob's barn. He's getting married on Saturday, and I'm supposed to have the barn completed on Thursday. There hasn't been any unusual weather. There hasn't been any termite problems. I've just not satisfied my obligations under the contract. It's Thursday and I'm not done. And in fact, I'm not even done on Friday. In fact, I'm not even done on Saturday. So Bob ends up getting married in a barn that's half painted. Very much less than ideal. And so I have breached the terms of our contract. Bob now sues me. He sues me for the damages that he has experienced because of my breach of contract. I clearly have breached, and so I decide, well, I want to settle this lawsuit. I know I'm going to lose. I might as well save some attorney's fees and not experience any additional fees than I absolutely have to. And so that's what I do. I settle it. I enter into an accord. That's that first part with Bob. And an accord is the agreement. And I say, Bob, I will pay you, we'll say $750. Obviously, Bob has a choice. He can accept my offer. He can reject my offer. He can counter my offer. But in this example, Bob accepts my offer of $750. So we have reached an accord. But we have one more step. We also need the satisfaction. So we write up the accord, we both sign it, it's a good deal for both of us, or at least we think it's a good deal for both of us. And now I present Bob with a check for $750. That's the satisfaction. Once I've done both of those things, we have a done deal. We have settled the lawsuit. You know, my initial obligation was to paint the barn by that particular date. But now I'm substituting a different performance, in this case paying the $750 instead of painting the barn by a particular date. Sometimes what happens in these situations is that a person owes a certain amount of money and decides, well, maybe I'll just pay a portion of it. So let's say, let's flip it around. Let's say I actually do paint the barn by the due date. I paint it by that Thursday. And so I come to see Bob on the Friday, go, hey, Bob, I painted the barn. I think it looks great. Bob goes to the barn. He looks at it, goes, yeah, you're right. It looks wonderful. It's going to be a great venue for my wedding. Thank you so much. And I say, okay, so I'm ready to get paid. And Bob says, oh, yeah, I owe you $2,000, don't I? I go, yep, you sure do. And so he goes, you know what? I'd love to pay the whole amount, but you have so many expenses because of this wedding. I just don't have $2,000 for you. But I tell you what, I will pay you $1,200 and we'll call it even. What do you think? Well, I'm thinking no. No, Bob. We agreed on $2,000, so that's what I'll need, the $2,000. That'll be what I need. And Bob goes, well, you know what? I just don't have that money. So I can pay you nothing, or I can pay you $1,200 and we'll call it good. Which one would you rather do? And I'm thinking to myself, oh my gosh, this isn't right. I wouldn't have agreed to paint the barn for just $1,200. So I don't really like that option, but I also need the money. So I say, well, okay, I'll take the $1,200. So Bob writes me a check for the $1,200. He goes, okay, so we're even now. Thanks for doing a great job. I take the check, I cash it, and then I sue Bob for the $800. The difference between what Bob was supposed to pay me, the $2,000, and the amount that he did pay me, the $1,200. I probably file in a small claims court. Bob shows up at for the case, and he goes, I don't know why I'm here. I told Groover that I would pay her $1,200, and that was all I was going to be willing to pay her, and she accepted it. If she wasn't satisfied with $1,200, she shouldn't have accepted the money. Well, whether or not that $1,200 payment satisfied, acted as an accord and satisfaction or not is going to turn on whether the debt that Bob owed me was liquidated or unliquidated. If it was unliquidated, then yes, we can settle the debt that Bob had for me for less than 100%. If it were a liquidated debt, though, any amount less than 100% is just a partial payment. The full amount is still owed. So if you paid 60%, you still owe 40%. So how do you know whether a debt is liquidated or unliquidated? Well, the example I gave in the barn painting story would be an example of a liquidated debt. The amount is clear. For example, in this case, I completed painting the barn by the date that I was supposed to, and both Bob and I thought that I had satisfied all of the terms of the contract. So I had fully performed my contract, and the amount that I was owed was unambiguous, was definite, was $2,000. We both agreed about that, so it was liquidated. It was a certain amount of money that I was owed. Under those circumstances, Bob's payment of $1,200 didn't make the $800 that he still owed me go away. He still owed it to me. But let's switch up the facts, and let me show you how it would look if the debt were instead an unliquidated debt. Let's assume that I'm supposed to finish the paint job by 6 p.m. on Thursday, but I don't get it done. In fact, I don't get it done until 6 p.m. on Friday. I'm a whole 24 hours late. The actual paint job I do is fine, but that has inconvenienced Bob. He's had to shift things around. The wedding rehearsal is being pushed to later in the day. He was going to have a barbecue for the rehearsal dinner, and now he hasn't been able to have it. They've actually had to rent some space at a local restaurant to host that event, so it's cost him money and some inconvenience. I have breached my contract. So it's not a situation where I did everything I was supposed to and was entitled to 100% of that $2,000. I am not going to be entitled to that whole 100% of that $2,000. It's a little bit unclear as to exactly how much of that $2,000 I am entitled to. There's a certain amount of ambiguity, a certain amount of uncertainty. When the amount is uncertain, we call it an unliquidated debt. And the parties can settle that for less than the whole amount. And if they do both agree to settle the amount for that amount, and the person who owes it actually pays it, so we do have an accord and satisfaction, then there is that substitution that happens. And under those circumstances, when Bob pays me the $1,200, it's resolved. You could also have an unliquidated debt if I met the deadline, but I didn't do a very good job painting. Maybe I missed some places, or I dropped paint or spackle paint on the glass, or maybe I painted the wrong color, or I used the wrong quality of paint, or whatever the thing might be. In some respect, I have breached the terms of the agreement. And under those circumstances, it can be a partial payment can qualify as a complete satisfaction of that debt. Sometimes contracts actually even provide for a liquidated damages clause if there's been a breach, and so it's not just so let's say, going back to the example, let's say I was 24 hours late. The contract might have even provided, say, for every hour it takes me over the time that I am supposed to complete it, I will receive $50 less than what I'm supposed to. So if that were a provision in the contract, instead of being owed $2,000, I would be owed 50 times 24. Let's see, what's that math? So because I was 24 hours late, and it's $50. So we have $1,200 is my penalty. So actually I would just be entitled to $800. Oh, sorry about that. Didn't mean to put a comma there. Oops. So if under these circumstances, let's say Bob paid me $600, because the amount that he owes me is certain, it's not ambiguous, it's not in the gray area, and he pays me $600, I can turn around and sue him for the remaining $200. So really, this is when things are uncertain. There is a dispute. A liquidated damages is when there is no dispute. This can settle for less, this can't settle for less. Okay, we've kind of already talked about this. A dispute for an unliquidated debt can be settled for less than the full amount. Again, here we have the definition of accord and satisfaction. So when can we have an accord and satisfaction? The debt is unliquidated, so we're not certain about the amount in the two parties don't agree with what's actually in dispute. The person who is owed the money agrees to accept this payment, not as a partial payment, but as complete payment. And the debtor, the person who owes the money, actually does pay that amount. You need all three of these conditions in order to have an accord and satisfaction that settles an unliquidated debt for less than the amount that at least one party thinks is owed. So now we're to the last element in our consideration rules. Okay, so the UCC, again, it stands for the Uniform Commercial Code. So we're not talking about the common law right now, we're talking about the commercial code. It permits considerationless requirements, contracts, and output contracts for the sale of goods. Okay, so let's go back for a second to look at our little cheat sheet. So what we're saying here is we don't need consideration, not needed for UCC requirements and output contracts. So there is an exception for this particular element. So as we said before, usually you have to have all of your elements. You know, it's if you don't have it, you don't have a contract. But there is this one exception for requirements and output contracts that are to which the UCC applies. Okay, so let's look at what we mean by this. Remember when we were talking about illusory promises, I said that we would talk more about illusory promises? Well, this is that moment. I did not deceive you. You're going to get your payoff here. Imagine this contract. I have a widgets factory. It's a small widgets factory, and you have a big toaster factory. You need widgets in order to put these in your toaster. Each one of your toasters has a widget in order for it to work. You actually source widgets from lots of different widget companies, and you've come to me and you go, you know what, Grover, your widgets are pretty darn good. We would like to buy your widgets, or at least some of your widgets. or maybe all of your widgets. We talk about it, we negotiate prices. It looks like we can make a deal. My widgets are priced in a way that you think is reasonable for your business model. And so you say to me, well, how many widgets are you going to be, can you sell to me? And I go, well, sometimes it's hard to know because there's been some labor unrest. There's also some raw material issues. Some of the materials I use in my widgets actually come from parts of the world that have some a conflict going on, and so sometimes it's hard for me to get all the raw materials I need. But you know what? I'm willing to sell you all the widgets I make. You will be my only customer. Well, in this situation, we're talking about an output contract. And so you say, you know what? I agree to that. However many widgets you can produce, I'll buy every single one of them. Whether it's one widget or 1,000 widgets or 1,000,000 widgets, I promise I'll buy each one of those widgets. Well, clearly, if we enter into this contract, you have made a promise. You have promised to buy all the widgets. So you have provided consideration. That's obvious. But the question is, did I, the widget manufacturer, provide any consideration? After all, I didn't promise to produce a single widget. I probably will. I'll probably produce a lot of widgets. I mean, once I have a guaranteed customer, why wouldn't I produce widgets? But I don't have a contractual obligation to produce a single widget. For example, let's imagine right after we sign this contract, we both go home, we go to bed. In the middle of the night, my widget factory gets struck by lightning. It burns to the ground. I wake up, I go to the factory the next morning. It's not there anymore. I decide, you know what? I'm not going to rebuild. I'm going to retire to the south of France. I have had enough of the widget business. But before I leave town, I call you up and I say, you know what? I'm not going to be able to produce any widgets. So sad, too bad for you. It's like, what? What do you mean you're not producing any widgets? We just signed that contract. I'm expecting to get lots of widgets from you. And I say, but wait a second. This was a output contract. I committed to selling you all of the widgets I produce. And I'm going to honor that contract. Every single widget I produce, I will sell to you. I'm just not going to produce any. So therefore, I produce 0 and I'll sell 0 to you. I haven't breached the contract. Well, that's an illusory promise. I control whether I produce a widget or not. I can produce a lot or a few. And so that's an illusory promise. It's like when I walked into the bakery and said, if I see something I like, I'll buy it. So that's why under the common law, output contracts are considered illusory promises. Let's look at how a requirements contract works, and let's see about the problem that we have with that. So now let's switch things up. This time, I have the big widget factory, and you have this small startup toaster factory. You still need one widget in each one of your toasters. You come to me and you say, hey, Gruber, I like your widgets. Let's negotiate a deal. We talk about the features you want in your widgets. And we talk about the price. It looks like we can come up with a deal. And so I say, well, how many widgets are you going to need? And you say, you know what? My widget demand is really going to vary. I mean, people buy toasters right before Christmas and Hanukkah, and they also buy it right before Mother's Day. And sometimes, in the May, June time when people are getting married, those are kind of our peak seasons for toasters. But you know what? Nobody's really buying a toaster in August or September. So there's going to be peaks and valleys. Plus, we're kind of hoping to enter into a big contract with Walmart soon. And if that happens, we're going to need a lot more widgets. But if it doesn't happen, some of my investors may decide to pull out, and I may not have as much capital, so I may not be able to grow my business as much. So the bottom line is I really don't know how many widgets I'm going to need, but I will tell you this. I am willing to enter into a contract with you that every single widget I require, I will buy through you. This is a requirements contract. An output contract focuses upon the manufacturer's output of that item. A requirements contract focuses upon the consumer, the buyer's requirements for that particular product. So anyway, I enter into this contract with you to sell you widgets. And what happens is that the very next day, Walmart calls you up and goes, we're not going to buy your widgets. And the day after that, your major investor pulls out, and you decide you've just had enough of toasters. You are going to go and convert your business into making microwaves, and you don't need widgets for microwaves. So you call me up, you go, you know what, Gruber, it looks like I'm never going to need a widget. I've switched my business model over to microwaves because Walmart and my investor pulled out. I said, but you promised, you told me every single one of your widgets you would buy for me. And you say, I'm honoring that promise. Every single widget I am going to need, I will buy from you. But I'm going to need 0 widgets, so I will be buying 0 widgets from you. Again, this sounds like an illusory promise, and it is an illusory promise. You control whether you actually have to do something under the promise. So again, under the common law, both output contracts and requirements contracts are illusory promises. Those contracts under the common law aren't considered contracts because the person who's making the illusory promise isn't really providing any consideration. The UCC, however, looks at these requirements and output contracts in a different way. The UCC says these do have consideration, they are contracts. And so they look at it differently. And this is why they look at it differently. They say, well, yeah, you're right, technically they're illusory contracts, but the reality is twofold. The first fact is that why would anybody enter into an output contract and then never produce the thing? I mean, that seems like a lot of hassle. Why would you go to that much work to say April Fools to the other guy? Business people really don't do that. Business people, once they get a customer who's willing to buy all that they can make, they tend to make a lot more. So it just doesn't make sense that that's going to be a common thing. Technically, it's an illusory promise, but as a practical way, it's almost never going to be truly an illusory promise. And so let's go ahead and honor that promise. Let's treat it as if it were a consideration because it's socially useful. Businesses find these types of contracts useful for their business. And if it's useful for the business, who are we to sit back and say, well, technically, it's not a real promise? Well, who cares about technical? We care about practical. Is this practically useful for businesses? Well, yes, it is. Well, then, end of discussion. We want to enforce it under those circumstances. So that's one reason why the UCC honors requirements and output contracts. But there's another reason, and that's this reason undermines the whole illusory promise idea. Now, I will tell you the common law still would treat these contracts as illusory promises, but there is something about contract law that we really haven't talked a lot about at this point, but it is important to be aware of. And this applies both to common law contracts and UCC contracts. When two people enter into a contract, they're choosing to enter into it. It's a volunteer situation. I don't have to enter into a contract with you. I'm choosing to enter into a contract with you. You don't have to enter into a contract with me. You're choosing to enter into a contract with me. And so we are doing it of our own volition. There's another aspect to it, and that is the idea that because it's a voluntary situation, because I'm choosing how to enter into the contract, whether to enter into the contract, and with whom I'm going to enter into the contract, I have a duty of good faith towards you, this person I'm entering into the contract with. And you have that duty towards me. Well, have I really satisfied my duty of good faith if I trick you? If I say, oh yeah, I've got this factory making widgets, sure, every widget I make I'll sell to you. When I know in my head, ha 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 ha, I'm never going to produce a single widget. No, not only would that be a ridiculous thing for me to waste my time to do, but I would also be breaching my good faith duty to you. Now, of course, if my factory burns down, that's a different scenario. I didn't know it was going to happen. So in that scenario, no, I didn't breach my duty of good faith to you. But in the ordinary situation, I'm not going to enter into a silly contract that I know I'm not going to honor just because I'm playing kind of word games with you. Let's see, we've already talked about this one, and we talked about output. Here's that discussion of good faith. And in this context, we mean honesty in fact. We can't lie to the other person. That would be a fraud situation, but we can't even intentionally hide facts that were important to the scope of the deal. So now we've gone through all 9 of our consideration rules. A contract is what a person will receive in return for performing a contractual obligation. That's our first rule. Oops, sorry, I went too far. For a promise to be enforced by the court, there must be consideration. Rule number 2. Promissory estoppel is the legal enforcement of an otherwise unenforceable contract due to a party's detrimental reliance on the contract. Rule 3. The court seldom considers the adequacy of consideration. Rule 4. Rule 5. An illusory promise is not consideration at all, except, of course, for number 9, which we'll talk about in a second. Past consideration is no consideration at all. Number 7 is a promise to do something that you are already obligated to do is not valid consideration. And these are kind of neat that we have these 3 together because they're all the circumstances where something that looks like consideration doesn't end up being consideration. And accord and satisfaction, keeping in mind this is 1 unit. That's why we say is instead of are here. And accord and satisfaction is an arrangement between contracting parties whereby one of the parties substitutes a different performance for his or her original duty under the contract. And finally, the exception to the illusory promise, rule number 5, we have rule number 9. The UCC permits considerationless requirements contracts and output contracts for the sale of goods. So hopefully this has been a helpful introduction to the topic of consideration. If you have any questions about this topic, please feel free to come to my office hours or send me an email about it or raise those issues in class. Thank you so much for your attention and have a wonderful day.